All right, good morning, everyone. My name is Grace Phillips, and I'm the editor-in-chief of the South Carolina Law Review, and I'm beyond grateful to everyone for being here and sharing your time for many of you and your talents for others. So thank you so much for being here. We look forward to a wonderful discussion this morning and this afternoon, and I'm going to turn it over to Dean Hubbard to get us started.
Grace, thank you very much. Thank you all for being here. I think this is an important event at this particular time, and your interest in it is very encouraging. For those of you whom I have not met, my name's William Hubbard, and I have the privilege of serving as dean at this remarkable law school. I want to acknowledge a few folks at the beginning who've been instrumental in the planning of this event. Certainly want to commend our editor-in-chief, Grace Phillips, and managing editor, Michaela Rushing, whose birthday is today. Happy birthday, Michaela. I also congratulate Jessica Brewer and Mariah Early for their efforts as Symposium editors, as well as the entire staff of the Law Review. I also want to thank Professor Derek Black for his participation in the planning and execution of this event, as well as Renee Woodley for her administrative support. It is a critical time for all citizens, and especially lawyers, to remain vigilant to protect the independence of the judiciary. In recent years and in recent days, attacks on the judiciary have increased, while public understanding of the essential role of the judiciary has diminished. Because the judiciary is constrained from defending itself publicly and limited in its ability to explain its role to the public and especially the organized bar must directly and forcefully address these attacks and defend the judiciary. Our constitutional democracy depends on the proper separation of powers, which of course includes an independent judiciary. The American Bar Association, the American College of Trial Lawyers, and other professional law organizations have steadfastly supported the independence of the judiciary and the status of the judiciary as a co-equal branch of government. In the words of the American College of Trial Lawyers, while our courts must be accountable, the college believes they should be accountable to the Constitution and the rule of law than to politicians and special interest groups. The privilege of practicing law carries with it the sacred obligation to protect the rule of law, one of the elements of a rule of law is an independent judiciary. The World Justice Project uses a definition of the rule of law based on 4 universal principles derived from internationally accepted standards. Principle 4 of that rule of law definition provides, justice is delivered in a timely manner by competent, ethical, and independent representatives and neutrals who are of sufficient number, have adequate resources, and reflect the makeup of the communities they serve. On June 15, 1215 at Runnymede, the barons secured the seal of King John on Magna Carta. At that site and moment was born the foundation of the rule of law and the principle that no person, not even the king or the sovereign, is above the law. You are familiar with Magna Carta's Chapter 39, which gave rise to the right of due process of law and the right to trial by jury of one's peers. Magna Carta's Chapter 40 proclaimed, to no one will we sell, to no one will we refuse or delay right or justice. There's another critical and scarcely known chapter of Magna Carta, Chapter 17, which provides, common pleas are not to follow the court, but are to be held in some fixed place. This chapter led to the creation of the Court of Common Pleas as opposed to the King's Court, which followed the king around the country and essentially did the king's bidding. Separation from the King's Court made it clear that judges were to operate independently of the king. This led to the development of the concept of judicial independence. Alexander Hamilton, a man of some modern popularity, placed judicial independence at the top of his list of reasons to take up arms in the American Revolution. He wrote extensively of its importance in the Federalist Papers. Justice Ginsburg stated that an independent judiciary is essential to the rule of law, and has stated that judicial independence, and I quote, can be shattered if the society that law exists to serve does not take care to ensure its preservation. Justice Kennedy, at a gathering in The Hague of Supreme Court justices from around the world, stated, and I quote, "Judicial independence is not so that judges can do what they want, but so that they can do what they must." Justice O'Connor, in her straightforward way, stated, and I quote, "Crisis in confidence in the impartiality of the courts is real and growing." She noted that 3 out of 4 Americans believe that campaign contributions affect courtroom decisions, and that many judicial elections have become, in her words, political prize fights where special interests seek to install judges who will answer to them instead of the law and the Constitution. These statements of Justices Ginsburg, Kennedy, and O'Connor were all made some years ago, well before the current controversies, but they are especially relevant and important today. Gallup polls between 2020 and 2024 show that Americans' confidence in the judicial system and the courts in the United States dropped 24 percentage points from 59% to 35%. This compares negatively to the 38 countries that comprise the Organization for Economic Cooperation and Development, essentially the developed nations, which as a group show increased confidence in the courts. So you can see the decline in the United States, but across the 38 countries that comprise the OECD, confidence in the courts has actually improved. Americans' trust in the justice system declined from 68% in 2017 to 56% in 2024. This data comes from the World Justice Project, Rule of Law Trends, Gallup polls, and other polls that are conducted in conjunction with the World Justice Project. In 2013, 80% of Americans believed in the guarantee of a fair trial. By 2024, only 65% believed in the guarantee of a fair trial. From the World Justice Project General Population Polls from 2017 to 2024, on the proposition that judges decide cases in an independent manner, we see a drop from 64% in 2017 to 47% in 2024. Alarmingly, from just December 2024 to today, we see a dramatic rise in the number of Americans who believe that our system of checks and balances is not working, from 34% in December 2024 to 68% today. 68% today who believe that our system of checks and balances is not working. Professor Tom Ginsburg of the University of Chicago said, "This is dangerous because when public confidence is low, the judiciary is subject to frontal attacks. In 2020, then Senate Majority Leader Chuck Schumer, in the context of the abortion decisions, called out justices by name and said, quote, "You have released the whirlwind and you will pay the price." And just last week, in response to the tariffs decision, the President described certain Supreme Court justices as a disgrace to our nation and fools and lapdogs who are unpatriotic and swayed by foreign interest. Both the American College of Trial Lawyers and the ABA issued statements on this past Monday expressing concerns about these comments. The American College said this: "By personalizing and politicizing his criticism of the court, the President threatens both the rule of law and judicial independence. Such rhetoric erodes public confidence in the judiciary if citizens are led to believe that Supreme Court justices are corrupt or disregard the Constitution. If citizens are led to believe that Supreme Court justices are corrupt or disregard the Constitution, faith in our system of justice cannot endure." The ABA said, "Such statements risk undermining the rule of law and the public's faith in an impartial judiciary, foundational pillars of our democracy that have guided our nation since its founding." Under South Carolina Rule 402K, every lawyer in South Carolina is required to take the oath of office as prescribed by the Supreme Court of South Carolina. That rule provides in part, "I will preserve, protect, and defend the Constitution of this state and of the United States." It goes on, "I will maintain the respect and courtesy due to courts of justice, judicial officers, and those who assist them." South Carolina Rule 407, the Rules of Professional Conduct, prescribes the responsibilities of lawyers. The preamble states, "A lawyer is an officer of the legal system and a public citizen having special responsibility for the quality of justice." It goes on, "As a public citizen, a lawyer should further the public's understanding of law and the justice system because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority." And finally, it says, "Lawyers play a vital part in the preservation of society." This law school seeks to inculcate those duties, obligations, and values in our students from 1L orientation through graduation. Simply put, without an independent and impartial judiciary, the rule of law is weakened. Without rule of law, we have chaos and oppression. Without rule of law, our democracy falters. To maintain the rule of law, we must all stand firmly for an independent and impartial judiciary. I know today's proceedings will enlighten us and give us more tools to support our efforts. Thank you very much for your attention.